A huge, very surprising twist to the Cyrus Mistry versus Tata Sons saga in the courtrooms. The National Company Law Appellate Tribunal, the NCLAT, has set aside the NCLT order that had allowed Cyrus Mistry's removal from Tata Sons, and rather unceremoniously at that. Now, this means that NCLAT has restored Cyrus Mistry as the executive chairman. The NCLAT also stating that Mistry's removal from other Tata companies is illegal as well. It has directed the Registrar of Companies, the ROC, to correct the records, also reinstating Tata Sons as a public company, not a private one. Let's get a 360-degree perspective on this case. We have Abhimanyu Sharma joining us from NCLAT. In Mumbai, my colleague Utkarsh Chaturvedi is giving us updates from the Mistry camp, and my colleague Neha Tyagi is getting us all the action from Bombay House. But let me go across to Abhimanyu first. Abhimanyu, if you can take us through what we've learned from the NCLAT order, the key takeaways from it.
Well, the NCLAT order essentially means that all powers and positions of Cyrus Mistry in the Tata Group have been restored, and the NCLT order has been set aside, which effectively puts him back in the same situation, position and designation which he was holding prior to his ouster following a board meet which took place in 2016 October. And the NCLAT has also made it extremely clear that the order which was passed by the board of directors on his ouster is illegal. Also, all subsequent decisions taken by the board have been set aside by NCLAT, which effectively restores all powers before Cyrus Mistry, and he will have power to review all the decisions which subsequently have been taken by the board. Also, NCLAT has ruled in favor of Cyrus Mistry and has made it clear that the Registrar of Companies will have to register Tata Sons as a public limited company instead of a private limited company. His petitions had sought a thorough probe. They had claimed mismanagement in Tata Sons, and it has been held by NCLAT that there was oppressive behavior from the side of Ratan Tata. What remains to be seen is how early petitions challenging this verdict would be filed in the top court, since it's also likely that caveat petitions will also be filed from the side of Cyrus Mistry in order to ensure that no ex parte order is passed from the apex court side in case the Tata Sons moves the apex court. And Tata Sons has a time of around 4 weeks as given by the NCLAT to implement today's direction.
So now this order comes into effect 4 weeks later. From then to now, from now to then, we've got an amount of time which we are trying to figure out exactly what Tata Sons will do, and we'll come to that in a moment. But what could be the possible next step from the Mistry camp? That's the important question to answer as well. Utkarsh is joining us with that. Utkarsh, not too long ago, we got a statement from Cyrus Mistry speaking about vindication of his stance. But tell us about what the Mistry camp could be considering next.
So I've spoken to people in the camp as well, and I was a while back trying to get some reactions from Janak Dwarka Das, who have been really, representing Cyrus Mistry all throughout. What all of them really say is that they know that this is not the final victory. They appreciate the judgment. They say that finally their stand has been vindicated, as it comes in the Cyrus Mistry statement as well. But the moment you speak to them off record, they're telling you that they know that this can be a long battle as well. Their first idea right now is to make sure that they file a caveat. This is what we have told our viewers a short while back. A caveat will be filed very soon in the Supreme Court, and that will happen. And then what they want is they don't want any immediate order from Supreme Court in this regard, but they do believe that this will not be a battle which is already won. They've said that this is one part. This is more of a battle. If you look at a war and a battle, this is more of a one battle one. But they know that the war is still on, and it will take much more time for them to really go ahead and get the final victory, and they're not putting their hands down.
All right, so they're going to go hammer and tongs, but to what end? That also needs to be answered, because is he willing to come back to Tata Sons? That's also a moot question that would need to be answered over a period of time. But right now, we're talking about a legal battle, and this is step one as far as the Mistry camp is concerned. What about Tata Sons? Now, between now and the time that this order of the NCLAT comes into effect, Their moves are going to be watched very closely. Already we've seen that deep impact that came into Tata stocks as a result of what NCLAT has passed as a verdict. But Neha, coming to you about Tata Sons, what are you hearing? What's the buzz as far as the verdict is concerned? What are they likely to do next?
Well, the statement, official statement from Tata Sons that was long awaited is finally here. They said that they are currently analyzing the 172 pages order that has been passed by NCLAT today. A couple of points or questions really that have been raised by Tata Sons in the statement that they put out today. The firstly, obviously, is that they want to know as to how the NCLAT order seeks to overrule the decisions taken by the majority shareholders of Tata Sons as well as the listed Tata operating companies at constituted as validly constituted shareholder meetings. The second question obviously is that the NCLAT seems to go beyond specific relief sought by Appellate. They are referring to the fact to the reinstatement order of Cyrus Mistry. So basically the statement has come in. They are looking, they strongly believe in their part of the story and that they are going to take appropriate legal action. So they will definitely be going ahead and appealing in the Supreme Court to seek relief. The board and the lawyers were in Bombay House discussing the future course of action. So we will clearly, in some time, we have time of 4 weeks, but we will clearly hear from them what exactly the next course of action will be. And going to Supreme Court definitely makes sense. As of now, we are right outside. We are expecting the board members to come out of Bombay House, and we'll try and get you some bites from them.
Now, we'll hear what the board also has to say, but this is the statement coming out. Neha is, of course, right outside Bombay House, like you just saw. And she's telling us that they're definitely going to the Supreme Court. So at this point in time, at least, an out-of-court settlement is not on the cards, at least going by what that statement says. We'll have to keep watching for developments. I want to thank Abhimanyu and Utkarsh and Neha for joining us with the latest, and we'll keep reconnecting with them as soon as we have more developments. But let's also get in a word from those who have been closely involved with Cyrus Mistry. For one, his counsel, Arima Sundaram, and his former aide, Nirmalya Kumar. Earlier this evening, we've been speaking to a slew of corporate law experts as well on this verdict by NCLAT. What could be the road ahead? What it is, again, turning out to be really one of the messiest boardroom battles of all time. These are the perspectives, kind of comments we got.
You must realize that the reason this whole matter went to court stemmed from the unceremonious removal of Mr. Mistry without following the articles of the company, without following procedures. And the whole case, the thrust of the case was that Mr. Mistry had been insisting on proper corporate governance, insisting on transparency in management, and that the interest of all stakeholders should be looked after. And the company should be managed by a neutral board rather than run on the diktats of the trusts who are majority shareholders. Now, all this boiled down to oppression and mismanagement under the Companies Act, more so, as we pointed out, because the Tata Sons has such a substantial controlling interest in so many companies in which there's a huge amount of public shareholding and public money.
So I do not have any inside information on what the Mistrys and the Tata Group will do because, of course, all options are being considered. This is very fresh news, so I suspect that both sides are considering what their options are at this stage rather than making any decisions for the moment. You see? So because it's just fresh, hot off the press. So basically, they're going to both consider their options and all options will be on the table and they will consider what they should do in the future. But the more important point over here is that, you know, these court judgments can go one way or the other way, but the truth does not change. And everybody knew the truth. And the truth was that what was done that day in October 2016 was an illegal act by the board. And nobody disputes that. And what this court has done, it has just followed the letter of the law. And it has said that what was done was illegal. And so, you know, but this is something we have said all along. So in a sense, you know, the court cases can go one way or the other. One cannot predict that. But what cannot go in either direction is the truth. And the truth was always known that what was done that day was an illegal act. Whether he wants to come back also is not entirely clear to me that he would even want to come back. The more important point to remember over here is that the board of Tata Sons, which is really responsible for managing Tata Sons, did something that was illegal in October 2016. If they have any moral fiber, they would resign today. The fact of the matter is, yes, the majority has a right to make the decision. But then what we are saying is that minorities have no rights. If the majority decides to do something, minorities should just shut up and take it. That's what he's saying in play. Secondly, he's saying people don't need to follow any process. If the majority decides that the process says in the bylaws to follow a certain process, but if you're the majority and you have the majority votes, you don't need to follow the process. I think this is, ridiculous from a corporate governance perspective. And, good corporate governance is we follow processes and we respect minority rights. Just because you're in a majority doesn't mean that minorities have no rights. Because otherwise, no minority shareholder should own any shares in Indian companies, because what the lawyer is effectively saying, the majority should be allowed to do whatever they want. Well, if that's the case, just tell me that before I invest in your company as a minority shareholder, and let me know that the majority has the right to do anything they want.
In fact, let me get Mohit Saraf to respond to that, because you're reacting to what he said. Mr. Saraf, just the point that Nirmalaya Kumar made, and taking that forward.
I think, I don't know what Nirmala is talking, but I'm sure that he does not understand the basis of law. The basis of law is the majority on the board will decide. Now, he's talking about a minority protection. Minority does not get right on the board meeting. They only have a right under the shareholder meeting. So I think really at the end of the day, the majority on the board decided. If they have decided, that is, unless it is against the law, unless it is against constitutive document, that's the article, it is a valid decision.
They should, bury the hatchet and come to amicable settlement. I think that's the best thing. Possibly one way would be that Cyrus Mistry would continue as the non-executive chairman, and Mr. Chandrasekaran would continue as the executive chairman in charge of the day-to-day running of the Tata Group. And that would be the best solution, where both sides are happy, because I think what Mr. Cyrus Mistry wants is more of a redemption. He wants that his name should be cleared, and the Tatas want that the group should be run by their own person, Mr. Chandrasekaran. So both would be happy if such an agreement could be arrived at.